name is Marty Shenkman, and I'm joined by several colleagues, and we are going to discuss a really important topic, the Reciprocal Trust Doctrine, and we're going to tell you why it remains incredibly important despite the election results. I'm going to be joined by Jonathan Blotmacher, Robert Keebler, and Alan Gassman. Before we get started, just a couple of administrative comments as well. And everyone's email and contact data is on the last slide in the PowerPoint, so you'll have information. And there'll be some materials as well as the PowerPoint posted. The program's free. We don't give official CLE or CPE credit, but you may be able to get a certificate of attendance when you attend if you can self-report. We will post the recording and all materials to the Shenkman Law website. Peak Trust and ILS Interactive Legal will also post the materials, so they're readily available if you miss it or want to share it with colleagues. If you have any questions, email the panel. The email addresses are again in the materials. Before we officially get started, we have a word from our sponsors, ILS. Teresa.
Hi, Marty, and everyone else. Good to see you all. And we are pleased to co-sponsor this webinar. Interactive Legal, as many of you know, is at its core a document drafting system, and this topic is important for us. So much so that I actually had one of our subscribers submit a question this morning asking us what our best practices were for drafting non-reciprocal trusts, because he was drafting trusts for spouses, creating trusts for each other. And so we are able to point him to what we have as what we call profiles that are dramatically different to directly address this issue. And so I'm interested to hear your thoughts, just to see, make sure they're in line with what we have in the program. And I look forward to the presentation. Welcome everyone on behalf of Interactive Legal.
I'm going to be bold and plug ILS a little further if you don't mind.
Sure.
So for those not familiar with document generation, and I think most estate planning attorneys are still drafting documents using their own forms or marking up existing forms, which is something I don't understand, because it'll transform your practice to use document generation software. And you may as well get on board because AI is coming and it's only going to get better and better and better. But what ILS has is two different templates. So you can do what I think is very strongly, and Jonathan, you can comment because it's specifically apropos to our topic today, two very different model documents that you still have a lot of flexibility to draft and tailor how you want for each client, but they've baked into them a whole array of differences to help you address the reciprocal trust doctrine. You can draft, and Jonathan probably say in 10 minutes each, but it's probably more like 45 minutes each, but in a very, very modest amount of time, two very sophisticated non-reciprocal slats that bake in a lot of difference. One of the things that to me is one of the powers of ILS that goes beyond just what document generation does is a concept that I think doesn't get talked about enough. And I'm going to just take a minute because I think it's directly on point to our topic today. When you have thousands of lawyers, and I don't know if ILS can even know how many lawyers use it because they only know how many subscribers they have, but there's thousands of subscribers, and somebody sees an issue, they email Teresa or somebody else at ILS and say, hey, here's an issue or an idea. So one of the things, which I'll take credit for, that I got them to do at ILS is one of the spousal lifetime access trust templates has more access points. The other one has less. That's part of how you have differences. And those economic differences is what makes it real for the reciprocal trust. And we're going to talk doctrine, and we're going to talk about that. But what I want to illustrate is when somebody that's a user of the system has an idea, and they don't listen to me all the time, which frustrates me, but they will vet the idea, they will listen to and if it's a correction, they'll jump on it. But what law firm has thousands of people, I think the answer is none, that use templates, and if they catch something, tell somebody and it gets fixed. There's a power to this sort of group drafting and creation of the forms that goes way beyond whatever the software and the people at ILS have. And in the context of the reciprocal trust doctrine, that's extremely important.
We also have
So,
the non-reciprocal SPAT too. Now, I don't know if you're going to talk about SPATs, but we have that with a broader access and a limited access, just like we do
right.
for the
And
SLATs.
the
So
reason I suggested that they label them that way is it makes it clearer which you're using. Because, for example, if you have one spouse, let's say the wife has significant pension assets, which you can't put into a SLAT because you're not taking them out of a retirement plan, which is asset protected and income tax deferred, yada, yada. But I may then make the husband the beneficiary of the trust with more access because the wife has a reserve of millions of dollars of retirement plans. It really helps you think it through. And when I made the suggestion, they said, yeah, that's a good idea. And they changed it pretty quickly. So you get the power of everybody. Alan, I don't mean to put you on the spot. Do you use ILS?
Yep.
Oh, good answer. What do you know? Jonathan, you don't use ILS, right? You don't know anything about it.
No, not much.
Jonathan is the creator of some of the forms and the I was going to say the brains behind the ILS documents, but I could say the personality as well. So it's really a very powerful thing. And when you go through the materials we're talking about in this reciprocal trust doctrine, think about these comments of how easy and quick and efficient. So instead of spending hours and hours and hours drafting the document, you can spend those same hours either interacting with the client or actually thinking about creative ways to enhance the plan. It's really empowering. So I know that was more than you bargained for, but it just fit this webinar perfectly. Andre is our other sponsor. Let me advance the slide. And when you set up your non-reciprocal SLATs, and I don't mean to jump the gun, but we're going to talk about it. One of the things that I like to see in non-reciprocal SLATs is different states, because you have the differences in state law. And Andre, I think you guys, you're going to tell everybody about Peak. I know I'm jumping the gun and talking too much. You have a presence and a function in both Alaska and Nevada, correct?
That's correct.
So I
That's
could
correct.
actually set up a non-reciprocal SLAT and have different states apply to each spouse's SLAT. Powerful.
And Marty, why is that important? Or we're going to cover that later.
Well, I think it gives you, if I have my wife's trust is with, well, because my SLAT started in Alaska 12 years ago, so it was governed by Alaska law. My wife's SLAT was in Nevada, governed by Nevada law. There's some material differences in each state law. So on top of any differences I may get from the documents, and we just talked about using document generation to do that, but apart from the differences in the document, I've now infused all the differences in state law that differentiate the trusts. Don't you think that's material?
It is.
I was worried you were going to disagree with me.
It's also very important for reasons that we're going to talk about later that creditors not be able to reach either of those trusts. You have a major creditor concern in a non-APT state. We'll talk about that later, but that's why if I'm ever going to do a reciprocal trust situation, both trusts are going to be in asset protection jurisdictions and good ones.
Yes, I fully agree. Andre, we got to let you talk.
Well, welcome everyone, and thank you for attending today's webinar. My name is Andre Sears. I'm the Business Development Officer for Peak Trust Company, and we're pleased and honored to sponsor today's presentation. Peak Trust Company offers a full spectrum of trustee services, serving individuals, families, and their trusted advisors. We specialize in complex trust administration and are particularly known for our expertise in directed trust and asset protection strategies. Our team provides flexible and customized administrative services for all types of trusts, from simple living trusts to sophisticated multi-generational wealth structures. I invite you to visit our website at www.peaktrust.com to learn more about our services. You can reach out to us at expert@peaktrust.com. Enjoy the webinar. Back to you, Marty.
Thank you, Andre. And for full disclosure, I've been a client of Peak since 1998. That's a long time. So let's get started. And I want to start with a what is really an important point that changes everything a little bit of the introduction, maybe not everything after that, but I think it changes everything in how we view the importance of the reciprocal trust doctrine to planning. The Republicans have swept the Senate, the House, and the White House. I'm not going to even ask the panel because I know they agree that it's highly unlikely, maybe not even that much, of a possibility that any harsh restrictions on estate tax are going to be enacted in the next 4 years, which gives us an incredible planning opportunity for our clients. But Jonathan, why don't you kick it off by giving just a quick, and keep it quick because I know we did a whole webinar on that. What is the relevance of the Republican sweep to estate planning? Why must estate planning continue? And then I'll ask Bob and Alan to chime in too.
Well, thank you, Marty. Estate planning is going to continue, and you're right. I doubt if there are going to be any harsh changes on the well-to-do, including on estate planning and estate taxes and gift taxes. Some people will actually speculate that this means that the estate tax will be repealed. Well, remember, Donald Trump got through his 2017 act, and they didn't repeal the estate tax. They just increased the exemption. And this reminds me of what happened in the year 2000 and 2001. George Bush said his #1 domestic agenda, this is when he was running for the presidency, was the repeal of the estate tax. Well, he won, and I knew, and everybody knew, well, that meant that the estate tax was going to be repealed, but it wasn't. And the reason was George Bush's advisors said, look, Mr. President, yeah, you can try to force through a repeal of the estate tax, but it costs money. And if you use that to get rid of the estate tax, you can't give benefits with respect to other things like income tax reduction. In my experience, people would rather have an immediate income tax reduction than, say, avoiding an estate tax, which is going to be imposed sometimes decades down the line on their children or grandchildren. Also, I've noticed that, and I've had clients tell me this, that the fear of the estate tax is a good fundraiser for the Republican Party. Because I had a client who was very, very wealthy, but he refused to do anything. And I said, well, why? You know, I got all these great ideas. And he said, I understand, but I know they're going to repeal the estate tax. I put in $1 million of political contributions to see that happen. Well, after 2 years, this is when George Bush was elected president, he came back to me and said, well, maybe I should do some estate planning. Now that was, you know, the better part of, you know, more than 20 years ago. And we still don't have a repeal of the estate tax, and I don't think it's going to happen. So the estate tax is going to be around. I think there is some chance that they will not have the decrease in the exemption, which is supposed to go from about 14 million to 7 million in a couple of years. But I think there's a good chance it won't, because again, there's a price to pay, and the price you pay is having a estate tax reduction compared to income tax reduction or something else you want. Remember, Donald Trump says, I'm going to avoid income tax on tips, on overtime, and even on Social Security. And the Social Security is really a big deal because the federal government pays out more than $1.5 trillion every year from the Social Security Administration. Now, some of those payments are subject to income tax, but many of them are. And even if you assume it's only a couple of $100 million, which would be lost by exempting Social Security payments from income tax, which now being an older citizen on Social Security, I really enjoy, you know, where are you going to get the money to pay for that? Now, you can have an increase in the deficit, but there will still be deficit hawks in the Congress and in the Senate who won't want it to be absolutely, totally wild. So I think you have to start, and I think you need to tell your clients, don't bank on a repeal of the estate tax. Maybe they won't have the automatic reduction by cutting the exemption in half beginning in 2026, but don't count on it. You still need to do planning, and you need to do your planning very, very carefully. Marty, back to you.
So there's 2 reasons, and we have 2 experts to talk each about one, that I think most clients I would say every, but there's always exceptions, but almost all clients should continue planning. And I'm not talking only ultra wealthy clients, but even mass affluent clients. Reason number one is, which I'm going to ask Alan to comment on, is asset protection. And reason number two is income tax. No one's talking about repealing an income tax. We have an income tax. So Alan, despite the Republican sweep, even if the estate tax were repealed, which I think Jonathan's made a good argument that you shouldn't count on it, and if it happens, we'll see, and it doesn't mean it's not reinstated. But asset protection remains vital. And to me, especially if you have a couple, the concept of non-reciprocal trusts is critical to that. So why don't you, and we'll get to more of this later, but I think just setting the stage why why practitioners need to be very mindful of the reciprocal trust doctrine remains very relevant because it affects that planning. Why don't you comment and explain?
Well, first of all, Marty, you're very right. And one of the things to think about is when you're sitting in that conference room with the client, they're very influenced by you as to what's important.
Yes.
So if you sit down with them and say, I'm really concerned about the federal estate tax, it's going to happen after you both are deceased and your children may lose 40%. Okay. But I'm also very concerned about your creditor protection planning. I mean, here's some news clippings that show that a simple car accident can cause a $274 million verdict. So I really want to make sure we cover that also. Well, then the client says, yeah, because what my kids pay when my wife and I are both gone, that's one thing. But what I have to pay now, that's another thing. And then that wife may chime in and say, and by the way, if I die first, he can leave all that to his next family and not our common children. That's what's important to me. So when you bring those three things up, the estate tax is not always number one, but the slat or a well-drafted couple of reciprocal slats can handle the creditor protection problem, can handle the inheritance problem, and that estate tax is going to be with us. If they take away the estate tax, when the pendulum goes the other way, which it always does, they'll be bringing the estate tax back. So that's the way I feel about it. A lot of my very best estate tax results have come from clients who came to me with creditor protection problems and didn't care at all about the estate tax. But the solution to the creditor protection problem was an estate tax proof trust.
And Alan, I think it's worth pointing out, and maybe you can just comment, isn't this concept of the reciprocal trust doctrine, which is our topic today, relevant not just for deflecting an IRS challenge to these trusts that couples set up, but also to deflect a creditor challenge?
Well, Marty, indeed, the first cases, the question is, who is going to be treated as the transferor, or if you have a trust, the grantor with respect to this property at a later time? And you might say, well, Marty's name is on it, so his wife Patty can't possibly be the grantor. Well, there are cases going back way more than a century where people were found to have actually made a deal. So someone created the trust for the person who's nominally the beneficiary, but is actually the transferor. And so it's all started with respect to what Alan was getting with respect to creditors' rights. I'm having a problem. I've been in a car accident, and actually I killed my neighbor's cat, and it was the only talking cat in North America. And the damage, as Alan said, was $274 million. Well, I had a trust created for me by my wife. So, traditionally, a trust created by a third party isn't subject to the claims of the beneficiary's creditors. But the creditors come in and say, well, maybe Betsy nominally created this, but it was really Jonathan because she had just received the money from him, or he did something for her. And there's a variety of ways in which it would come up. But remember, bad facts make bad law. There's a very famous case out of Mississippi about 20 years ago called the Sly case, in which a man got in a car accident. His parents had created an absolutely spendthrift trust for him, but he had crippled a man in this car accident. The man sued, And the courts just couldn't stand it, that they couldn't get, that the man who was injured couldn't get at the assets in this spendthrift trust. And they said, no, we're going to let it happen. And Mississippi had to pass a whole new set of laws to say, no, you really can create a spendthrift trust. But if you've got bad facts, you may get a very bad result. So if you're going to do something, whether it's for tax purposes, which most people think about when they think about the reciprocal trust doctrine, or creditors' rights or some other reason, which is much more common, you've got to make sure you do it the right way to avoid the application of the reciprocal trust doctrine, because you're going to have the creditors and the tax people come after the person whom they believe should be responsible for the damage or the tax.
The other reason to continue to consider non-reciprocal trust planning is, in addition to estate tax, which I agree with the comments Jonathan and Ellen said, even if it's repealed, it may very well come back. And we don't know that it's going to be repealed, and we don't even know for sure that we're getting a reduction, the reduction in the exemption will or won't go through, the bonus exemption. But Bob, maybe just comment why this type of planning could be so useful for families from an income tax perspective.
Sure. And before we go there, I want to just spend 30 seconds, Marty. What Tax Note reported yesterday is the extension of the Tax Cuts and Jobs Act could be as short as 4 or 5 years. So if all we're getting is a 4 or 5 year reprieve, it really doesn't change anything from what we've been doing. So we're moving forward, unprecedented territory. Now, the good news is the House and the Senate drafting committees are already working on the tax legislation that will be introduced in January. So we could see these bills, what they're going to look like by the end of January, early February, and then we'll have a sense for how long the TCJA 2.0 extension will last. Now, coming back to the income tax. From an income tax perspective, we always have to be thinking, how do we reduce federal income tax? How do we reduce state income tax? The low-hanging fruit in states like New York or California may be to create non-grantor trusts outside of the state. And if those are drafted correctly, you can avoid state income tax. Now, some home states will allow you to do that. Other states will not. There's a backdrop of constitutional issues of how far states can go to limit that. That's litigation that was in the Kaisner case, not quite the same, but eventually the Supreme Court will look at this issue of whether Wisconsin can stop my wife and I from creating a Nevada trust and avoiding Wisconsin tax going forward. That same statutory scheme is in many other states. But there's a lot of other helpful things we can do. I could create a non-grantor trust instead of a grantor trust when I create my dynasty trust, and then I can sprinkle income from that trust across my family, potentially reducing my rates. So there's a lot of planning. The article that I'm helping with right now addresses some of this, because there's other things too that if we think the estate tax is going to change meaningfully, there's charitable trusts, charitable remainder trusts, charitable lead trusts. There's all kinds of planning that's a little bit tangential to what we normally do.
Jonathan, can't you have non-reciprocal spousal lifetime access trusts? And even if you're not worried about the estate tax, which I think we've already kind of made it clear for the long term, you still should be regardless. And if you're ultra high net worth, you have to be. But even for a more moderate wealth client, if we create non-reciprocal slats because we want to have asset protection and we want them as non-grantor trusts, explain the mechanism of the adverse party and how we can have our cake and eat it too, if you will, that we can create a slat. So again, if we're creating two slats, we need to address the reciprocal trust doctrine, our topic today, and still have them as a non-grantor trust to get the income tax, state income tax savings Bob is talking about.
Well, yeah, the problem, Marty, is that when you create a trust for the benefit of your spouse, Section 677 of the Internal Revenue Code tells you that's a grantor trust with respect to you. Now, this, for people hearing it the first time, seems a little contradictory. Wait a minute. I'm creating this trust for my wife. She's the beneficiary. I have no interest in it, but you're saying that I have to pay the income tax on it? Yes, that's the way it works. Even though you're not a beneficiary of the trust, Section 677 says if you create a trust for your spouse, it's going to be a grantor trust with respect to you. So if that happens, you're not going to really save any money because the income is going to be attributed back to you, even if it's received by your spouse. Now, you might say, well, what's the harm in that? Well, one of the harms, as Marty said, is if you live in a state like New York or New Jersey or California, most states have an income tax, you're not going to save any income tax. So you want to do something, you say, well, does that only apply if my wife is the only beneficiary of the trust? No, if she's merely a discretionary beneficiary. You create this trust for your spouse and for your kids and for your brothers and sisters in charity. Guess what? It's going to be a grantor trust with respect to you unless. And one of the big unlesses, unless the distributions to your spouse can only be made with the consent of an adverse party. An adverse party is defined in Section 672 of the code. And it seems like it's a very straightforward definition, but when you take a look at the case law, and there's extensive case law on it, it's just not always very clear who is an adverse party. So you might think that if I create a trust for my wife, but I say that my son is going to be one of the remainder beneficiaries, and the trustee has to get my son's permission to give any distribution to my wife, well, he's an adverse party. That's what you would read in Section 671. But the regulations and the cases in particular state no, because they might decide that my son wouldn't dare go against my wishes. So if I wanted property to go to my wife, my son won't dare say no because I can still disinherit him with respect to other assets. So it's not always clear, but you need to put it in. And what my recommendation is, if you're going to try to have a trust where your spouse is an eligible beneficiary, but you don't want it to be a grantor trust, you have to put in that distributions to the spouse can only be made with the consent of an adverse party within the meaning of Section 672. Don't specify who that is. We'll figure that out later, but that way you've fallen right into this exception that Section 677 says it's going to be a grantor trust with respect to you. Very, very important. There's one other thing. Let's say you've got a couple, they're very happy, and Marty creates a trust for Patty, Patty creates a trust for Marty, everything is great. But my wife decides that she's going to steal Marty as her boyfriend, and Patty doesn't like that, and they wind up getting divorced. Well, the trust that Marty has created for Patty will continue to be a grantor trust with respect to Marty, even if they get divorced or separated. So one of the things you want to do if you're creating trusts for a spouse is to make sure you have a mechanism, either by saying, if my spouse and I get divorced or my spouse and I separate, it can only be distributed with the consent of an adverse party, or no distributions can be made to that former spouse. Very, very important to put that in your doctrines. You can imagine how unhappy your client would be if you go to them and you say, Marty, I've got bad news and I've got worse news. The bad news is that this trust you created for Patty will continue to be for her benefit. I mean, that will drive him up the wall. But what is worse is to say, and oh, by the way, Marty, you have to pay the income tax on all income that's distributed to your spouse. So please, if you're going to have anybody create a trust for their spouse outside of the reciprocal trust doctrine, make sure you turn off the ability of that spouse to get distributions in the event of a separation or divorce, unless you say it can only be done after the separation or divorce with the consent of an adverse party. Very, very important.
So let me recap where we are, and if any of you want to make a comment, I'll give you a minute and then we'll go on. The whole point of this preliminary discussion was to set the stage why, even after the election, the reciprocal trust doctrine remains critical to planning. So first, Jonathan explained that there's no guarantee the estate tax is going to get repealed. Alan pointed out, and I agree, even if it did get repealed, which who knows, if there's a Democratic administration and things always wax and wane, it probably is going to come back. I mean, the Democrats have made it very clear that they want to use taxes on the wealthy, especially estate taxes and transfer taxes, to dampen the wealth concentration in the country. So to assume that we don't need to plan doesn't make sense. But even regardless, ignoring the estate tax, non-reciprocal trusts need to remain a foundation, a cornerstone of planning, because as Alan explained, most, if not all of our clients should be doing asset protection planning. And the reason slats, non-reciprocal slats, are so vital to asset protection planning, unless the client's uber wealthy, they need access. And what better way to give access than to have spouses, each spouse a beneficiary of the other trust? I mean, there's other ways, but that's not our topic today. So for most clients, asset protection remains important. Access remains important, and the way to do that for married couples is non-reciprocal slats. And as I think Alan explained, or Jonathan did, the creditors can use the reciprocal trust doctrine to uncross the trust to reach the assets. So it's not just a tax doctrine, it's an asset protection doctrine. And
Right.
then as Bob,
And in fact, you may win on the creditor issue, but you still could lose on the tax issue. Maybe you're in a circumstance where, you're going to different states, as was suggested a little while ago, Alaska and Nevada, or Delaware and South Dakota, whatever you want to do. You have different states, but still, even if you win from a tax perspective, it doesn't mean you're going to necessarily win from a creditor protection point of view. But if you lose from the creditor perspective, you're going to definitely lose for the tax purpose. So you've got to look at both of these very, very important concepts of reciprocal trusts for tax purposes and for creditor rights purposes as well.
and even apart from creditor rights, even apart from estate taxes, as Bob explained, using non-grantor trust is a cornerstone of planning to minimize state and potentially even federal estate tax. And Jonathan explained how you can have non-reciprocal slats be non-grantor with the introduction of an adverse party to approve distributions to a spouse. And we didn't talk about upstream planning. That's another concept. So the whole point of this elongated introduction was to make it clear that drafting and planning with non-reciprocal slats is absolutely relevant and critical and a foundation of planning, even after the Republican sweep in the 2024 election. So
let me just say one more thing. We're talking about non-reciprocal slats, but the first federal case involving basically the reciprocal trust doctrine didn't involve spouses, it involved brothers. They were two of the Lehman brothers. And as a consequence, if you go in and say, well, this guy doesn't want to include his wife, or she doesn't want to include the husband, or maybe they're not married, but there is a sister or a cousin or someone else. So I go to my cousin Barbara and I say, Barbara, I'm going to take $5 million and create a trust for you under the protection of my remaining, lifetime exemption, and you take $5 million and create a trust for me. If that's found out, guess what? You're going to be just like the Lehman brothers, and you're going to lose. And not only does that mean you're going to have a tax problem, as the Lehman brothers did, but you're also going to have creditor problems to boot.
Alan, do you want to sort of set the stage of what the reciprocal trust doctrine is? And then Jonathan, maybe you can comment. Like, what is this? Where did it come from? What's it about?
Right. So if I set up a trust for myself, then under the tax code and under the creditor laws in most states, my creditor can reach the maximum amount that the trustee is able to distribute to me. And the IRS can assert that the trust assets should be included in my estate for estate tax purposes, because I put the tree in the trust and I retain the right to eat the fruit. And 2036A is very powerful. I mean, you could give away the whole farm, but just have the right to keep one cow on the farm, and that puts the whole farm in your estate. So maybe I'm clever, and I set up a trust for my wife, Marcia, and then a few months later, Marcia sets up a trust for me, and the trust I set up for Marcia benefits Marcia. The trust Marcia sets up for me benefits me. And the creditor comes in or the IRS comes in and they uncross it. They say, what you really did economically, Alan, was you set up a trust for yourself because these were reciprocal. So I think that sets the stage.
Jonathan, I know you talked about Lehman. Do you want to elaborate a little about some of the backdrop to the reciprocal trust doctrine?
Well, I mean,
we got to talk about Grace, for example.
well, yes, I mean, that came in later, but the Lehman Brother case is interesting because they had the same lawyers counsel both brothers. The brothers put the same property in trust for the other brother, and the powers were the same. They were entitled to all the income. And apparently the advisors never realized, and there was, again, backdrop under common law dealing with creditors' rights, that basically you were going to uncross these trusts and say that the party who is the beneficiary of the trust was actually the grantor. And the courts had no problem in saying Section 2036 would apply. That was kind of out there. There were a few cases, but it all came to a head in 1969 in the Supreme Court's case of the state of United States versus Grace. Now, for those of you who are of the Catholic persuasion, this is a state of grace, not state of grace. So I don't want anybody to be confused. Mr. and Mrs. Grace, again, using the same lawyers, using the same property, created trust for each other. And when Mr. Grace died, the Internal Revenue Service took the position that the assets in the trust that his wife had created for him were in the estate because in substance, he was the transferor of that property. Now that's kind of as bad set of facts as you could have, but what you want to do is to begin to make distinctions here. And Marty, do you want to take over and telling us some of the distinctions that people possibly could make?
We're going to get through a lot of that, but let me start by talking about what I think the most fundamental distinction is, and I would like to hear any of you that want to comment after I do chime in. And I think this is fundamental to how we deal with trying to deflect a reciprocal trust doctrine challenge. To me, what the estate of grace, the primary, as I read it, and others may differ, the primary focus of the court was that the parties were left in the same economic position after the planning as they were before the planning. And that's kind of what was inherent in Alan's comment and Jonathan's discussion of Lehman, where they had the same rights into the same property. So I've seen and heard, as I'm sure all of you have, people lecture or write and talk about all sorts of different kinds of differences that could be built into each of the two trusts. But to me, the focal difference is how do we impact a change in the economic position of the parties? So for example, as Jonathan pointed out, in Lehman, they had the same assets, and Grace had similar assets or the same assets. If simple-mindedly, and I'm going to use husband and wife just because it's easier than spouse one and spouse two to keep track of it. If husband put 13 million, 14, let's just call it 14 million because the exemption's 13,990,000. So let's just call it 14. The husband put 14 million of a bond portfolio in a trust for wife and descendants, and wife put 14 million of growth equities in a trust for husband and descendants. Arguably, they're in a somewhat different position than they may have been before. If husband's slat that he creates for the wife has a $5 million insurance policy and wife's trust has no insurance, the economic quantity of assets, nature of the assets, the economic impact on each is quite different because now that insurance policy, I think, changes the nature of it. If husband can get distributions out of wife's slat pursuant to a broad standard, but wife's distribution rights from husband's slats are either zero, meaning maybe not during husband's lifetime, or restricted, you're building in economic differences. To me, those are the fundamental things to focus on, is making sure the parties are not in the same economic position. And one of the things that concerns me, and I haven't seen any case law on it, and if any of you have, please jump in and tell me. what worries me is, let's say husband creates a slat for wife, and wife creates a slat for husband, and they're both pulling money out, getting distributions on a regular basis, and those distributions are paying for all the lifestyle expenses, the cruises, the cars, and everything else. I get worried what's being done with what. So if wife gets a distribution out of the slat husband created for her, puts it into a joint bank account, and husband buys a car in his name, that's not a good set of facts. Is he getting economic benefit out of that trust? Now, it might be different if it was set up as a self-settled trust or something like that, but out of the typical slats, I worry that one of the things that undermines this fundamental, as I view it, point of different economic position is what happens with all the indirect benefits after the client leaves our office, right? We can all talk to the clients about what they should and shouldn't do in the administration of the trust, but who's monitoring these? Who's paying attention to them? So I think the fundamentals are the economic differences, and that's something that we really need to focus on. So as I said, different assets, different distribution provisions, and we're going to talk about more of these later. Insurance coverage in one but not the other, or very different coverage. And I remember in the old days, and I don't know if there was a case on it, but I remember having discussions, and this was before the reciprocal trust doctrine became such a hot topic. It was very common to do insurance trust for husband and wife. It was a standard part of planning. And Alan and Jonathan, I don't know if you did it any different, but it was very common, before 2012 when people did insurance trusts, that nobody really talked about the reciprocal trust doctrine very much. There weren't, in a lot of the insurance trusts, they were basically identical with name changes. I'm not saying that was right, but that was pretty common. But
It was very common, Marty. And again, when I would see that, and these were the arrangements that I wasn't the principal advisor on, I would call the lawyer who was involved and said, what about the reciprocal trust doctrine? And the typical response was, what's the reciprocal trust doctrine? And somebody came back and said, well, look, there's no benefit right now. So, you can't have a situation where you say that, a husband's getting something from the trust his wife created, and wife is getting something from the trust the husband created. But when you look through, I think this would be pretty close to a slam dunk for the IRS in contending that, basically that each of the spouses had retained an interest in the trust. And, that would be very, very troublesome. If you're going to create trusts for the husband and for the wife, you've got to make them substantially different. In fact, whenever I've done this, I would have only one spouse created and not tell the other one about it, and then wait as long as you can, at least many weeks, if not many months, before you even go to the other spouse and say, look, George created a trust for you, Janet, and maybe you would like to consider having you create a trust for George. And if you can establish, and the best way to do that is with an independent corporate fiduciary who can swear up and down, look, I never told the other spouse about this. It came up at a later time, months later, and she or he decided to make that distribution back. And of course, you also want to put in tremendous differences, as Marty said, different standards for distributions, different times for distributions, different assets, different advisors, different state law, so that it's not going to be as easy as the IRS or a creditor could make it by saying, look, this is nothing but, A was scratching B's back and B was scratching A's back. Very, very important to do that.
one of the differences or analyses that I used to have discussions about in the pre-2012 common spousal ILIT planning was that the differences in age and gender made the insurance policies have different economic implications. Any thoughts on that?
Well, Marty, I think that is an argument that one would make, that, the wife was, if she's the same age, she's more likely to survive, so she's more likely to get a benefit. But you've got to build in other things, like when my wife and I did our trust back in the year 2010, I created a trust for Betsy and gave her a tremendous number of rights, including the ability to change trustees whenever she wanted without allowing her to put in someone who was related or subordinate to her, which you have to do because of Revenue Ruling 95-50A. But I also put in that the trustee could get over a unitrust interest. She had a lifetime special power of appointment. And that came up with a very, very important case with the IRS. And I don't know whether you have it in here, Marty, but the Levy case.
It comes up. It's coming up later.
But Mr. and Mrs. Levy had basically identical trusts, except that she had a lifetime special power of appointment. He did not. And the IRS conceded in its brief, and the tax court agreed that that prevented the trust from being considered reciprocal. But keep in mind, there was a concession in the IRS brief that that was a sufficient difference. And some people have argued, well, if you don't have that concession from the IRS, the court may not say anything about the Levy case. So you shouldn't use that as the only difference that you're going to make between the two trusts. But make sure that you have some independent person who can verify that the spouse who was the second one to create the trust was unaware of the trust that the first spouse had created for him or her. And there was no understanding at all the differences you want. Marty and Bruce Steiner, I guess it was, wrote a very good article many years ago about this. I wrote one with Mitch Gans and Diana Zadel a number of years ago. You've got to make the differences real. And again, please don't do them at the same time. Don't use the same assets. Don't use the same advisors, and don't use the identical trustee. But having a corporate fiduciary in who will verify that they only got this from, say, the first spouse, and it didn't come up with a second spouse until months later, is something very important to consider.
Let me qualify your comment a little bit. The reality in practice is clients will show up at the last minute. Alan, have you ever had clients come in early? They always come at the last minute. Isn't that like part of the requirements to be a client? So in 2020 and 2021 as examples, and in 2012, when we thought the exemption was going to go down, people showed up way late. And in 2020 and 2021, we thought there would be a bill passed any minute that could prospectively eliminate grantor trust and everything else. So we did, and everybody did planning, where sometimes you had no choice but to set up the trust in a very short time period or even the same day. Not ideal. What Jonathan said is ideal. And if you can have the luxury of time, which we may now have with 4 years of the Republican sweep, to do the planning with lots of time between steps for the step transaction and time between the trust and the planning for each trust for the reciprocal trust doctrine. But the reality is there's times in practice when you don't have that. I want to just make a point on slide 17, unless Bob or Alan, if you want to talk about the Bischoff case for a second, just to demonstrate it's not just spouses.
Well, the other thing, Marty, that you get from the Bischoff case is that they applied the reciprocal trust doctrine even though they didn't both have entitlement to income, which is where the Lehman case and the Grace case and other cases have gone, saying you were deemed to have retained the right to income. And of course, under section 2036A1, if you create a trust and you have retained the right to income, even if there's only an implied understanding, you have estate tax inclusion. 2036A2 doesn't retain to the right to receive the income, but to control the benefits in the trust. And that's what was used in the Bischoff case. Now, there have been some statements that that really shouldn't apply. But as I said, when I and my wife did ours, I gave Betsy a lifetime and testamentary special power of appointment. She didn't give it from me. Give it to me. And the reason was I was worried about the estate of Bruno Bischoff, that the IRS might say, well, there was no entitlement to income, but Jonathan, we're going to say that you retained this right to control the ultimate benefits of the trust under section 2036A2. But again, we didn't each have it, so that helped to say it couldn't apply.
Any comments on the Green case where the taxpayers were victorious?
Well, again, Marty, I think this shows that if you make it sufficiently different, that, you know, you can go ahead and go pretty far. But again, That was only a Sixth Circuit case. It's now, 30 years old. So I don't think you can say that, you're definitely going to win.
So let me bring us back to something that Bob had commented on earlier and ask a question. And then let's talk about the realities on slide 19, because I've heard a lot of people lecture where they're adamant you have to have X number of months or X amount of time between each trust, or you have to do this or that. And I don't think there's any bright line rules, but let me pose a question. So Bob was talking about tax planning, and Jonathan talked about different assets in each trust. So what if we put a income producing asset in the trust that husband creates for wife, and a non-income producing asset in a trust that wife creates for husband? And the income producing asset in the slat husband creates is structured as a non-grantor slat, so that we remove it from high state income tax. But the wife's trust is not structured as a non-grantor trust, it's a grantor trust. Does the mere difference of grantor versus non-grantor, does that seem material to all of you to differentiate the trust for purposes of the reciprocal trust doctrine?
It's helpful.
Helpful, but certainly not dispositive, Marty. I mean, it's the problem is this is a very subjective doctrine. Grace gives us some bright lines, but you still have to evaluate, do you even want to take the risk of structuring reciprocal trusts? There'll be some families that you represent where there's enough wealth that there's no need to do reciprocal trust. If somebody comes into you, they're worth $60 million, their cash flow, they need $400 a year to live on. They can probably have husband create a trust for his wife, and wife just create a trust for children, grandchildren, great-grandchildren, and not even go near the reciprocal trust. So you have to think about this from a financial perspective as much as from a legal perspective, because there's going to be some clients that simply do not need that second spousal trust.
So my concern with that, and I think it's important to acknowledge there are no bright line rules. It's all a measure and a way. And a lot of the cases are limited in the facts, or the facts are bad. So it makes it very hard to really determine what quantum of difference measures up. But the problem with clients, and even at a $60 million level, I've seen clients with a very significant multiple of that wealth, have such high lifestyle expenses that they need access. I've had clients with more wealth than that reluctant to make a gift of their exemption amount, even to a slat, because their burn rate was so high. And we've all seen clients like that. So it's very relative to the wealth of the client and their spending level. But what worries me is, even when you do financial modeling and you feel that it's reasonable to do it, and Alan, I want you to comment in a minute on the tax burn implications. But even if you do financial modeling, there's a lot of scary what ifs out there, right? Somebody develops a significant health issue. Insurance won't cover very costly medications. Stuff like this happens, and not infrequently. So it worries me that unless I have a client, and I'm not going to use an absolute dollar term like 60, but I get where you come up with the number, but it worries me not giving significant access, because if you don't give significant access and one of those bad things happen, now you have a client that doesn't have money to live on. And Alan, I know you love numbers, and you've been looking at numbers just on the tax burn, but conceptually, and I know you could talk for a whole hour on it, but just take a minute. How far off can people be when they look at these numbers? Because I agree with Bob's comment, but it worries me.
Marty, that brings up the question of, does the client really need to do reciprocal trusts, or are they just neurotic? Because, people who have 20, $30 million in net worth and want to put 10 million of it into two irrevocable trusts, do they really need that kind of access? If you run the numbers, are they putting away too much? When Brandon, my partner, and I run numbers with Jerry Hesh on a lot of examples Jerry's given us, sometimes the people do give away too much and they run out of money. And the reason they might run out of money is the burn. The fact that the more that builds up in that dynasty trust or that slat, the more income tax the person is paying. So as Jonathan said, you've got to be able to plan to be able to toggle off by having the adverse party. But another way to approach this, and I don't know if I'm changing the subject here, and I apologize if I am, but we typically don't do what we would call reciprocal trust. We typically have the wealthiest client who's going to die the first, who earns the highest income. That's usually the older husband in most couples. He does a slat for the wife and descendants. The wife does a dynasty trust in an asset protection jurisdiction. And the dynasty trust in the asset protection jurisdiction is just for the descendants, except that if one of the spouses has a tremendous loss of net worth and would otherwise really not be able to maintain their standard of living, then trust protectors who are not fiduciaries and have no duty to do so can add a spouse to that dynasty trust. It doesn't look like a slat. It doesn't smell like a slat. There's no intent to benefit each other. The intent is just to have a back door. And when we run the numbers and show the clients, you don't really need to do reciprocal slats. There should be plenty in the one slat for you guys to live on. If you spend that much, do you really want to do these? We will typically end up with one slat and one dynasty trust just for the children. And then the clients have to decide, do I want to put that dynasty trust in Florida or wherever I reside? Or do I want to put that dynasty trust with Peak Trust Company in an asset protection jurisdiction so that we can have a back door? And the other thing I'll say is they can borrow from these trusts. So yes, we do have clients who have a $3 million home and not much else left, and they're 91 years old, and they're living off of a trust that they gave to their children, but the children are getting a mortgage on the $3 million house. And 91-year-olds don't spend all that much unless they have nursing care issues. So I'm sorry I just went off on a tangent, but I just wanted to make sure we covered all that.
This is very important. I want to connect the dots. And Jonathan, just let me finish because I'm going to turn it back to you to talk about your favorite topic of spats. But this discussion is fundamental to differentiating the trusts that are created and keeping cognizant of the fact that on page 19, there are no bright line rules. So what Alan was talking about, and let me just try to summarize real quick, a couple of vital concepts. And this ties back to what Bob said. Every client's different. You really ideally want some real forecast done to see what this all means. And the results can be from here to here, depending not just on the wealth they have. Bob used an example of a good number like 60 million, but it's how much they spend relative to their wealth. We've had clients with $30 million that don't spend a penny, and we've had clients with hundreds of millions that I can't even conceive of the budgets they have. And they never have a budget until we insist they get one. So you really need to look individually. I'm always concerned whether it's what I said about unexpected expenses from medical or other issues that come up, or what Alan said, they don't perceive the impact of the tax burn, that you need access. But one of the ways to get access, and Jonathan, you should comment, which I think also differentiates the trust, and Alan just phrased it a little differently than I do, but we often do the same thing. I may have a SPAT or a hybrid DAPT provision in one trust and a SLAT in the other. Those, I think, are material differences that give you access. I'm very worried about clients running out of money and then stretching the envelope of how much they're really accessing something beyond what is appropriate. Jonathan, how would a SPAT versus a hybrid DAPT or a DAPT differentiate the trust rather than doing just two slats? Because that seems to address both my worry of access and the reciprocal trust doctrine.
Well, to begin, Marty, for me and for some of the others, I'm going to define some of these terms. ADAPT is a domestic asset protection trust. And there are now somewhere in the neighborhood of 22 states in the United States which permit you to create a trust for your own benefit, but deny access of your creditors to that, provided you weren't trying to defraud a creditor at the time you created the trust. A hybrid DAPT is something where you are not an eligible beneficiary at the beginning, but someone has a power to add you. There's a case in New York called Ionati, where someone created a trust and there was a trust protector who could add the grantor back in as a beneficiary. And the New York court said, basically, we're going to treat that as a self-settled trust, and it was subject to the claims of creditors. So that's a problem. Now, I developed with others, Mitchell Gans and Abby O'Connor of Alaska, the concept of the special power of appointment trust. And this is very similar to what Alan was talking about. I create a trust for my wife and descendants and maybe siblings and maybe charity. And it says I can never receive a distribution from this trust, ever. Even if there's a decanting, I just can't. And that means it is not going to be includable in my estate, because even though I'm going to give somewhere between 1 and 3 people in non-fiduciary capacities, and they are not beneficiaries of the trust, the ability to make a distribution to any descendant of my mother. Now, I'm a descendant of my mother, so these 3 individuals or any one of them could go ahead and say, trustee, make a distribution of 100,000 or $1 million or whatever they feel I deserve to Jonathan. That does not make it a self-settled trust in any jurisdiction. If you take a look at the commentary to section 505 of the Uniform Trust Code, it says the only way that it becomes subject to claims of creditors, and this has now been changed in 22 states, but even if, you have that say, well, we don't care that, you were in a state like Alaska or South Dakota, the fact that the guy was from California or could have come from California, we're going to say it's subject to it. But this says, because it says it's only to the extent that trustees or fiduciaries can make a distribution to the grantor of the trust. So you want to make sure that you're in a situation where you specifically state you cannot make a distribution to the grantor by a trustee, even if you decant the trust. But again, you give 3 independent people in whom you repose trust a power in the non-fiduciary capacity to be able to appoint property to the grantor. Now, you might say, well, Alan said, they give it to trust protectors. Isn't that okay? Well, Alexander Beauvais, who got his PhD by writing up a thesis about trust protectors, has taken the position that all trust protectors are fiduciaries. Well, he and I went to dinner with our spouses a few years ago, and he conceded with me that if you went to Alaska, where it says that a trust protector is not a fiduciary unless the instrument explicitly says otherwise, and you state that the trust protector is not a fiduciary, then he probably is not. But you would have that little bitty issue. So these are individuals. They're not trust protectors. We don't care anything. It's just Tom, Dick, and Harry, or Mary, Joanne, and Ruth have this special power of appointment, which they can exercise in favor of any descendant of my mother, which would include me. Also, it will be helpful if you don't tell them that they're getting that power at the time the trust is created, because the IRS sometimes, and creditors also sometimes, will argue there was an understanding that it would be exercised. Well, if these people can verify, and again, if you have an independent corporate fiduciary and your counsel will verify, we didn't tell these people that they had the power in the trust, I think it is impossible for the IRS to make a credible claim that there was an understanding that they would exercise their power in favor of the settlor in the event that the settlor had a need. So that's something that I would do. And this, by the way, avoids the reciprocal trust doctrine, as Alan was saying. Yes, I've created a trust for my wife. She hasn't created a trust for me. She created a SPAT, a special power of appointment trust. And the trust says it's for, she's created this trust, but it's only for our descendants. But she's named 3 people. Maybe it's her 3 siblings, or maybe it's cousins, or maybe it's friends. But only one of them needs to have the power to go ahead and appoint assets to any descendant of her mother or anyone married to her mother. So that means it could also go to me. And I think you've now gone very, very far of foiling the reciprocal trust doctrine.
So to me, we've talked about a number of different concepts. The tax burn is often grossly underestimated. Alan has demonstrated that in other programs. We're not going to talk about it today. Clients don't perceive, a lot of advisors don't perceive of what time can do. Compounding is the eighth wonder of the world, right? But you have that issue. I respect Bob's comment, but I always get nervous about limiting access. But how do you give more access and not run afoul of the reciprocal trust doctrine? And I think what Jonathan and Alan just talked to is, to me, at the heart of how you resolve some of all of these issues, because they're all interrelated. And you can't just talk about the reciprocal trust doctrine without talking about forecasting and tax burn and access and spending levels and whether or not they need it, because Bob's right in some cases. And Bob, you should comment about your caveman example in a minute. But if you shake it up and don't just get hyper focused on doing two slats and what do I do to make them different, but you do a spat and a dynasty trust, a hybrid DAPT and a slat. I mean, you're giving very different powers, rights, and more access, but making the trust, I think, economically different, that should address the reciprocal trust doctrine. But you're not doing so in just a vacuum. It's not just checking off a box of, okay, I got these differences, it should be enough. You're rather trying to tailor it to the needs of the spouses. And like we said earlier, if you have one spouse that has pension assets or an inheritance trust that they have indirect access to, maybe that's the spouse who gets the slat that has less access, and the other spouse gets the spat or something with more access. So I think you want to move away from a template of an answer or a boilerplate answer to tailor it to work for the circumstances, because not only can you then differentiate it for purposes of the reciprocal trust doctrine, but you do so in a way that works for the clients. Bob, I know you talked, it was a caveman trust?
Well, here's the very simple example. You represent two 90-year-olds. We'll make it easy. And they say, we each need $100,000 a year to live on. So husband puts $1 million in a trust for his wife. Wife puts $1 million in a trust for her husband. And together they put $26 million in a trust for children, grandchildren, great-grandchildren. What we've done is we've just reduced the reciprocal trust risk from $28 million down to perhaps $2 million. So what I'm encouraging people to do is look at this from a financial structuring perspective. Now, 90-year-olds are easy because the runway is very measurable. Very hard to do for a 65-year-old. But still, the concept is there'll be some people where instead of me creating a $14 million trust for my wife and my wife creating a $14 million trust for me, we will ratchet down the slats and just do a large dynasty trust for our children and grandchildren together. And those assets are totally protected, no risk of 2036.
The reason I think this is so brilliant and so simple, it's like a V8 moment. Clients don't think, oh, I can spend down principal, right? So, and you can't use table life expectancies because clients tend to live longer, and the table life expectancy is only 50 percentile, right? So you want to go further. So if table life expectancy is 87, you go out to 97, 100, 105, whatever it is. But clients can spend principal. And that's the heart of what Bob is saying. If you have a realistic budget and you have a forecast that goes out long enough, and the clients understand, no, I don't have to live off the income of what I'm doing. I can spend down my principal because it's enough. Then you can do this type of planning that Bob said, and you greatly reduce the risk profile. Let me go back to something I think Alan said about loan provisions. Why can't we do what Bob just said, two smaller slats, but let's do a spat and a slat, or a slat and a DAPT, or hybrid DAPT to mix it up more. But why can't I have a loan, or why not have a loan provision in the dynasty trust that neither spouse is? a beneficiary of. So if wife sets up a $20 million dynasty trust, and forgive me, I don't remember the number Bob used, but just in his example, can't there be a loan provision in that trust? Can't that trust make a loan to either spouse if there's a financial issue? Alan, Bob, Jonathan?
At arm's length, sure.
Well, most people think that if you're going to loan, you can loan at the AFR. It's not entirely clear that loaning at the AFR doesn't mean you haven't retained an interest in the trust, but certainly you could do that. And again, if you make it an independent person who has to approve the loan, you can go ahead and do it. Worst thing that happens is the IRS comes in and says, this was all wired. But again, if you have the person who can make the loan was unaware of that power at the time it was granted, I think it's impossible for the IRS to use that in order to trigger the reciprocal trust doctrine or some other way to say that the grantor was really the person who was controlling when the loan came back to him or her.
So let's get back to the outline, and I think hopefully what we've done is change up the discussion of how the reciprocal trust doctrine is looked at in a very practical way, and demonstrated how it's integrated with all these other decisions, from tax burn to spending to budgeting to what the people really need, the fact they can spend principal, not just income, and that you can change it up and get more than just two plain vanilla identical slats. And just doing the kind of things we've talked about, I think you've made huge inroads in deflecting a reciprocal trust challenge. But more importantly, you've tailored the planning to what the client's needs are and their specific facts, which is even better planning. In the Levy case, which is one of the cases that's quoted a lot, Jonathan, you mentioned it, but Alan, do you or Jonathan want to talk about Levy? And in particular, while I think it's a great concept of one of the differences, I think a lot of people have relied on Levy and saying that's enough. If I have that power of appointment, I don't need anything more. Would one of you like to comment?
I nominate Jonathan.
All right. This is one of my favorite cases because it looks like they fell right into a state of grace type situation, which again was that 1969 Supreme Court case where they used the same assets and the same advisors and had the same trustees and both were entitled to the income. The court said that the reciprocal trust doctrine applied. And Levy had the identical facts. They used the same lawyer, they used the same trustee, they used the same assets. The only distinction was the husband gave his wife a broad lifetime special power of appointment. And as a consequence, the taxpayer argued, and the service conceded in its brief that if that power of appointment was a valid power, and they argued for reasons that were not upheld by the court, that the power was exercisable any way that she wished. And the IRS conceded in its brief, and the tax court found that prevented the reciprocal trust doctrine from applying. That one distinction, the fact that one of the spouses had this power. I would not rely on that. I've always used it when I've created it. And for example, I told you I gave my wife lifetime and testamentary broad powers. I had none, but we went ahead and we distinguished them, but we also put in a lot of other changes, which you're going to want to do. But this is a very good case. But again, the IRS conceded in its brief, and that may be why the court came out that way. And again, it's only one case. It's a tax court memorandum decision, which doesn't even constitute official precedent at the tax court, and it's certainly not going to be binding on district courts or courts of appeal. So again, don't rely on that distinction alone.
I think that's a really important point. It's a great difference. Use it. Don't rely on that as the sole difference. Jonathan, let me ask you a question in light of the idea of there's really no bright line test. A very well-known practitioner that I know used the Levy general, broad power of appointment and a 5 and 5 power in one trust, and neither of those in the other trust, and felt that was sufficient. What say you? And Alan, you can comment too.
Well, I'd say they're skating on pretty thin ice. I certainly wouldn't do it. I mean, you've also got to remember your clients don't want to have litigation or controversy. I mean, you've set up this great plan. The IRS comes in, they say, well, we're not going to have it happen. And all of a sudden you wind up having hundreds of thousands, if not millions of dollars of litigation expense. And clients always worry about litigation because, it could turn out very badly. So, relying on that alone is just not enough. You want to make yourself a very unhappy target for the Internal Revenue Service. They have to overcome a lot of things. So they're going to look for someone who's easier to pull out of the tree rather than you. You want to be at the top of that tree, hidden away in the branches, so the IRS doesn't even come at you. So,
Jonathan,
whatever.
I'm sorry to interrupt you, but is this going to be the first webinar where you don't use your analogy of don't be the low-hanging fruit?
Oh, yes, Marty, that's true. Don't be the low-hanging fruit. The IRS is always looking for the easiest case to collect money. I'm going to say something very controversial, and I know that Alan, Bob, and you, Marty, as well as everybody listening is going to feel I'm a very bad American for saying this. But in my experience, the IRS is only in it for the money. And it wants that easy to grab money. And you've got to put yourself so far up in the tree that the IRS says, nah, let's find some other tree with someone on a lower branch that we can pull out and wring money out of that family's pocket. You don't want to make it easy for the IRS. Even if they decide they're going to do something, the chances of your compromising it in a way that's pretty darn good is still there as well.
Alan, any comments?
Final comments?
No, we're not done.
No, I think Jonathan hit the nail right on the head. He's exactly right.
Let me make a couple of comments. And again, one of the things that we're trying to do in this webinar is change up the discussion, right? We talked about why this is so relevant even after the election. We've talked about how it integrates with financial planning, spending levels, and everything else. I think one of the very important points that doesn't get enough airtime with the reciprocal trust doctrine is the impact of the decisions involved in differentiating the trusts, like if the spouse is divorced. And Alan, you can comment in a minute, but let me just make a couple of points. Let's just take the 5 and 5 power. And I mentioned that there's a very well-respected practitioner who felt that having the Levy broad power of appointment in one trust and a 5 and 5 power in neither in the other trust was sufficient. I don't disagree at all with Jonathan and Alan that, you want more if you can get it. But let's just talk for a second about the 5 and 5 power. So if you put 14 million in a trust, and I'm not going to try to do the math, but 5 and 5 let you pull out 5%. So say husband sets up a trust for wife, and it's a second marriage, and wife pulls out, let's say husband becomes incapacitated, is not aware or dies, but wife starts pulling out every year 5%. It's over $500,000 a year. Over 10 years, it's $5 million. They may have had an arrangement that the marital assets are going to get divided half to husband's kids from a prior marriage, half to wife's kids from a prior marriage. But if wife starts exercising that 5 and 5 power, after really a short number of years, that's a big economic impact. And she could direct all that money to just her kids. So I think the economic consequences of these powers in different distribution standards can be really significant. And that's what makes them real, which is how you deflect a reciprocal trust challenge. But clients have to also understand that's what makes them real and they could be used. Any comments, folks?
I still agree with Jonathan, Marty. I agree that you've got a distinction there, but maybe the taxpayer in Levy got really, really lucky. It's an unreviewed case with one tax court judge. So I think the more differences, the better.
Right. And again, the IRS conceded in its brief that if the power of appointment was valid, and the court found it was, that the reciprocal trust doctrine shouldn't apply. And the court found it didn't apply. But again, the fact that the IRS conceded it in its brief made it a layup for the judge. The judge didn't even have to think about, well, is it really, you know, that important? Hey, you know, the other side conceded it. It became the law of the case. So yes, you're going to use that distinction. You're going to use others, but you're not going to use that alone. You're not going to use, you know, one had a power of appointment, the other one did not. The one had a 5 and 5 power of withdraw, the other one did not. Because to the extent that things are there that you can put the husband in as the wife and the wife in as the husband, if there's no, or to the extent there is not an economic difference with respect to them, I think you have a good chance of falling into the reciprocal trust doctrine.
What about the comment that I just made about the economic implications of one spouse exercising that disparate 5 and 5 power? Nobody responded to that.
Well, Marty, it depends, maybe it depends on whether or not it's actually exercised. I mean, if we're talking many years down the line.
Husband and wife set up non-reciprocal slats. Wife there's lots of different powers that make you both happy, but wife exercises that 5 and 5 power. Husband's incapacitated the next year. For the next 20 years, she's pulling out 5% of that 14 million as it grows and giving it to her kids from her prior marriage. Completely disrupts the entire estate plan. Comments, thoughts? These powers are real.
Well, Marty, you started with the premise. You said the spouses create non-reciprocal trusts. You assume the premise you want to prove. I don't think you can start. No, you said right at the beginning they create non-reciprocal trusts.
Because I wanted to focus on the impact of exercising these powers, not just when you give different rights of distribution and different powers to each spouse, there is a real economic impact on those. Well, I'm not talking about the reciprocal trust doctrine. I'm talking about the real economic impact of these.
You don't know that. I mean, you said, well, look, let's take a look 20 years down the line. The husband's, had a stroke. He doesn't do anything. He doesn't exercise his power. But, I don't think you can say what happens after the fact makes it a non-reciprocal trust. I don't think you can do that.
That wasn't the point I was making. I was making the point of the economic impact to the family.
Bob wanted to say something.
No, I just wanted to bring back, maybe it's a little off track, but in Grace, they focused on part of a plan. And we've been talking for 2 years here that we'd set up one trust in 24 and one trust in 25, trying to put more than 12 months between those steps. Assuming the Tax Cuts and Jobs Act is extended even 4 or 5 years, there's no reason that I cannot create a trust for my wife today. And then 3, 4, 5 years from now, she can evaluate de novo whether she creates a trust for me. And I think we want to put that in our calculus of when you're drafting, because there's not as much urgency on that second trust right now.
That's a huge point, and I'm sorry that I didn't bring that up when we were talking about the impact of the election. We now have what seems to be 4 years where it's highly unlikely that we're going to have an adverse tax change. And whether or not they extend or don't extend the bonus exemption, and whether or not we get 4 or 5 years, as Bob has mentioned, as a possibility out of an extension of the 2017 Tax Act, we have the ability now to put years between our planning steps. And that certainly should help break a reciprocal trust doctrine. Just to wrap up the point I was trying to make that nobody seemed to like, I think it's important to point out to clients that the differences that are built into the trusts are real and do have real economic impact, and that's why they work. And the client should be aware of that, because I just gave one example. People may act on those, and you don't want one spouse that has less access because of the differences built in being unhappy with the plan later. Clients often don't focus on what we're telling them. So a suggestion, just a thought, put in a memo that you send with the client just saying these differences have real economic impact and you should be aware of that. So they can't come back later and accuse counsel of doing something that they didn't understand that has a negative impact. Let's just see if there's any other points that we want to go through to wrap up on the differences that were built in. So we've already talked about different powers of appointment. Here Here are some of the other things. Different jurisdictions, we talked about that. I don't know that we mentioned different beneficiaries. One of you want to comment on that, Alan?
Well,
Bob?
that's certainly useful to do. Doesn't hurt. Bob?
Well, I think, but keep in mind, when you're looking under 2036A1, my thought is the court is going to look to what rights does my wife have and what rights do I have? And I'm not so sure whether how G2 or G3 or G4 or G5 is includable in the trust makes a difference. So if I did my trust for my wife and two of our children, and she did it for me and the other two children, I'm not so sure that even counts as a difference. I mean, there's just no case law on that.
What about I name my mother-in-law as a beneficiary in the slat that I create for my wife? I now have another beneficiary, and so that my wife's economic interest arguably is watered down because there's another person that's a beneficiary.
That's a meaningful difference.
And oh, by the way, why don't I do upstream planning while I'm at it and give the client an income tax benefit?
Marty, explain that.
I give my mother-in-law a general power of appointment over the slat I create for my wife, a formula general power, so that on her death, she has a general power of appointment so that assets in that slat that I created, when added to her own estate, are $100,000 below her exemption amount. So we now get a basis step up on that amount of assets in the slat, not when we pull them back into my estate through a swap power when I die, but rather in a reasonably short number of years when my elderly mother-in-law dies. So I get an income tax basis step up, which is a great income tax play, and a reason to continue doing this planning even if the client is not worried about the estate tax. Plus, I've now differentiated, I think, the trusts because there's another different beneficiary between my trust and my wife's trust that reduces her economic interest. Thoughts, folks?
Well, Marty, I think that could work. And as you say, you do it as a formula. So the general power of appointment is she has a general power over the assets in the trust to the extent that the assets in the trust, together with her own exemption, her own property does not exceed her remaining exemption at the time of her death.
Again, a broader perspective, folks. So even if a client feels fence sitting because they don't want to plan because, gee, the Republicans will extend the bonus exemption, Bob pointed out it may only be for a limited number of years. Alan pointed out, political winds change all the time. So I think the planning makes sense. But hey, if you throw in another beneficiary to help differentiate from the reciprocal trust, and oh, by the way, now we got an income tax play, I think you're starting to not only get a better quality plan, but arguably another tax benefit for the client that may entice them to go forward with the planning.
That's a good idea for the planning, for sure.
Right.
Clients are very open to getting the new basis step up.
Right.
No
but keep in mind, to get the new basis step up, the party who currently owns the assets is going to have to make a transfer. So you're going to have to make a taxable gift, use part of your exemption in order to get the step up in basis when your mother-in-law dies.
Right. And that could be the slat, or that could be a slat.
Yep.
We've talked about using different trustees, and my default approach is to use an institutional trustee and different trustees in different states. I think that gives you two differences, and it gives you, and Jonathan and I think Alan as well have commented multiple times about the independence of an independent trustee. One of the things I've seen a lot of people, practitioners do, and the comment is always the same, that's what the clients want. And I agree with Alan. It's a little bit how you frame it when you talk to the client at the table. But I've seen them use the spouse. So husband sets up a slat for wife and names the wife the trustee. Wife sets up a slat for husband and uses husband trustee. I don't like that at all. Comment, thought?
No, I mean, you think you're stepping deeper into the reciprocal trust arena.
Yeah, I agree. And I think that if clients really insist on that, you should try to convince them otherwise. Again, my preference is different institutional trustees. On a smaller plan, that's not going to be feasible. They won't do it, but name different friends or family members. Don't name the spouses. I'm not saying it's absolutely wrong, but it's certainly not where I would go. We've talked about different powers of appointment. We've talked about the power of the 5 and 5 power. Any benefit to different marital savings clauses? So in the slat I create for my wife, there's a Q-tip as a marital savings. In the slat my wife creates for me, it's an outright marital if it's included in her estate. Alan, Bob, Jonathan, any thoughts on that?
Those are other differences. Could be a very serious difference if one trust is outright and the other trust is maybe just a power of appointment. I mean, you could, I think it's the economic position of the two parties that created each trust. And if those parties are in the same spot, nothing changed, and you're going to have a 2036A1 problem. If you can create enough differences, you have a very good argument that 2036A1 doesn't apply.
And I think what we're doing through this discussion is we've gone through we've rattled off a pretty, and talked about a pretty growing list of differences to build in. We've talked about spats, we've talked about timing, we've talked about different assets. I like using insurance to differentiate the trusts. We've talked about, I don't know if we've talked about it specifically, but maybe different funding levels. And this kind of goes back to Bob's planning, where you don't need to put the 14 million in a slat. Maybe you put 4 million in a slat and 10 million in a dynasty trust on one side and 14 in a slat on the other. You got wildly different asset values in the slats, and you've reduced your exposure and made the plans look different. So we've covered that as well. This is the point that you guys didn't like when I talked about it earlier, but I think it's important to explain to clients that these differences are intended to put them in different economic positions. So they will have an economic impact. And if one of them dies prematurely, and you should talk about insurance, but if one of them dies prematurely or there's a divorce or whatever, those differences could be stingy and the clients may not love them. So make sure they understand, to make this real, it's got to be real, and there's consequences to it. Any comments, guys? Alan, any other comments on financial modeling to understand all this? I know we've talked about it, but I just think it's so important and doesn't seem to get enough attention.
Yeah, when you run the numbers and you see the spreadsheets and you show these to the clients, they understand them. And clients are getting more and more sophisticated, and Bob's found that. 12-year-olds are now handling Excel spreadsheets, and 70-year-olds who are executives, doctors, anyone who has an accounting degree or finance degree these days, they're all running spreadsheets. So run a spreadsheet and send them the spreadsheet and let them come up with the situation. They'll love to know that they have plenty of assets and that they don't need to have control over everything. They don't. Most of these wealthy clients, as I said before, they really don't need reciprocal slats. They're fine with one slat, and they'll discover that when they look at the numbers.
I think there's another aspect to it, which I don't want to belabor. It's not our topic, but it's really, really important. If a client gets a financial analysis done before they do the plan, it's a different type and level of understanding than the verbal discussions without the numbers. And if a client is later unhappy with the plan, and you, the practitioner, have in your file, well, look, I sent them a forecast, they saw what the numbers were, I think that's very protective for the practitioner. Alan?
Yeah, I agree with you.
Absolutely.
Not only that, but it's revealing. It is, when you run numbers for somebody, it is always revealing. You're spending too much. You're gonna run out. Stop spending so much. Or you have so much more than you thought. Are you sure you don't want to do something for charity? And
You need the numbers to say that.
Enough for each child. It's running the numbers is always, we're off on a tangent here, but running the numbers is really important.
I don't think it's such a tangent, Alan, because I think it's a deeper and more methodical way to address the reciprocal trust doctrine, because by looking at numbers, you can come back and say, hey, like you and Bob have pointed out multiple times, maybe you don't even need the slat provision, just make a dynasty trust. Or maybe you should be putting less into the slat. Or maybe we'll do one slat for 14 million and the other will just be a dynasty trust for 5. You need numbers to kind of do that. And whether the attorney does it, the accountant does it, a wealth advisor does it. Somebody should do numbers. And Alan, I'm going to be a nice guy. Do you know any software that does these kind of projections?
I heard there was one called Estate View that can help with some of this. But I want to point out that Bob is such an industry leader at providing, this service when so many CPA firms are no longer having time or inclination to help families run these spreadsheets and run these numbers. But yeah, seeking out these spreadsheets and numbers, it's important.
Final couple of comments and we're going to wrap up. This can apply these concepts even outside of just trusts. It can apply to gift plans. And just for a pause, Jonathan talked about the Lehman Brothers. It was brothers, siblings, not spouses. We talked about, I'm blanking on the name of the case, where it was trust for, I think, grandkids, not for spouses. Now it's not just trusts, it's outright. Alan pointed out how this doctrine applies to creditors as well. So the reciprocal trust doctrine is not only about slats, it's much broader, and we need to be mindful of it. I think we're done, and why don't we just go in order and let Jonathan, then Bob, then Alan make any concluding comments, suggestions, or thoughts. Jonathan?
Marty, I think we said it all. You've just got to be very, very aware that the IRS wants your money, and creditors will come after you anytime they feel. Nobody is going to say it was my responsibility. Everyone wants to blame someone else. So, and the most protective thing I think you can do for your clients is to get them to create trusts.
Bob?
Remember, when you're giving advice, Tax Cuts and Jobs Act's likely going to be extended 4 years. It gives us some more time to plan. And also run the numbers, because again, if I can do a smaller slat for my wife, less money is going to be exposed. And the other thing, from my experience in handling dozens and dozens of estate and gift tax audits, is it's going to be very hard to settle a $14 million times 40% issue. But if it's $2 million times 40%, 800,000, it may be easier to settle that. So take a look at the numbers.
Alan?
The US v. Grace case did not address the creditor's rights in those trusts. The IRS did not bring it up. If the IRS had explained to the tax court that either of these spouses could have run up a bunch of debt and have the debt paid from the trusts, then the court in US v. Grace may have come to a different conclusion. You really cannot rely on that case. The same thing in the Levy case. If the IRS had argued that it's as simple as this: Marcia's trust for Alan, creditors can reach into. Alan's trust for Marcia, creditors can reach into. So why can't that be included for estate tax purposes? If you're going to do these, do them in an asset protection jurisdiction. And even then, understand that if your client lives in a non-APT jurisdiction, you can't be 100% sure that creditors can't reach in unless you go offshore. So be very careful about this reciprocal trust doctrine. And if possible, don't do reciprocal trusts.
So we've tried to, I thank Jonathan and Robert and Alan for their comments. I don't think we got off field. I think that was intentional, because I think if you approach the reciprocal trust doctrine in a broader, more holistic manner, looking at not just spouses, but siblings, grandchildren trust, non-trust gifts, if you look at it from a creditor protection perspective as well as a planning perspective, if you look at all the other reasons to do financial analysis and how it may impact the planning, you can come up with a much more tailored plan that's safer for the client and works better for the client. And a lot of the things that we tried to demonstrate is you can help differentiate a trust and possibly get a income tax benefit by income splitting with somebody, by using non-grantor trusts and differentiate, by having another beneficiary, and so on. Warn clients, and I would suggest you consider doing it in writing, that these differences can have real economic impact. That's why we're doing them, and that's the only way they're going to work, but they should be mindful of that. I don't want a client coming back and yelling at somebody, gee, you didn't tell me that, you know, my rights to income or access were so restricted. Think broadly, SPATs, DAPs, hybrid DAPs, all the acronyms. You broaden the thought process. Bob's caveman trust that he described with, you know, only a couple $1 million in a slat. There's lots of options. I think one of the biggest dangers to practitioners is having a template of a plan that they use for many clients. With the software that's available, drafting software, projection software, we can really tailor this stuff and I think get a better result. And I think planning is going to be different post-election, but I think the reciprocal trust doctrine is going to remain a very significant aspect of the planning we do. So thank you, everybody, and I wish you good luck. And thank you to our speakers and our sponsors.
Thanks, Marty. Really appreciate it.